Mr. Clerk.
For the record, Resolution 15-13. You have before you Committee Report 15-5 recommending the following. 1, that the proposed resolution entitled Approving the Appointment of Patrick K. Wong as the Corporation Counsel be adopted. 2, that the correspondence dated January 16, 2015 from the Department of the Corporation Counsel be filed. And 3, that County Communication 15-26 be filed.
Mr. Couch.
Thank you, Mr. Chair. May I request a short recess?
Yes. Recess. The council meeting shall come back to order. Mr. Couch.
Thank you, Mr. Chair. I move to adopt the recommendations of Committee Report 15-5.
Second.
It's been moved by Mr. Couch, seconded by Mr. Carroll to pass Committee Report 15-5. Mr. Couch.
Thank you, Mr. Chair. Your Policy and Intergovernmental Affairs Committee met on January 22nd, 2015 to discuss the appointment of Patrick K. Wong as the Corporation Counsel. Your committee notes that Mr. Wong has been serving as Corporation Counsel since 2011. Your committee commended Mr. Wong and his staff for their professionalism in representing county agencies, officers, and employees. Your committee was satisfied that it had done its due diligence in considering Mr. Wong's suitability for the position. Accordingly, your committee voted 9-0 to recommend adoption of the proposed resolution entitled Approving the Appointment of Patrick K. Wong as the Corporation Counsel and filing of the communication. I respectfully request the Council's consideration of the motion.
Members, further discussion? Mr. Carroll.
Thank you, Chair. As we all know, in the earlier meeting, we had 54 people come over here with various reasons to deny Mr. Wong's approval at this time. And we had a lawyer come over here and cite several parts of the law code, which I have no idea what he was talking about. But the concerns were serious, and I would like, if the committee would allow, to have Mr. Wong come down over here and answer some questions, because I don't think it's fair to have public testimony given and not have the person in question be able to clarify or perhaps answer the concerns that our community has, if there is no objection.
Members, any objections to asking Mr. Wong to come down?
No objections.
No objections.
Objection? Mr. Wong, would you please join us? Thank you, Mr. Carroll. And if the committee is all right with it, we'll allow Mr. Wong to make an opening statement.
Chairman.
No objections.
Chairman.
Yes, Mr. Holcomb.
We are in a council meeting, sir. This is not a committee review. This is a final council review and action situation. Thank you.
Mr. Wong.
Thank you, Chair. Thank you, members. It's with great pleasure that I sit here before you, ready to respond, if necessary, to any of the allegations raised in prior testimony. Let me generally state that I appreciate the testimony provided today, the extensiveness of it, and the willingness and passion within which the testifiers have presented. I respect their opportunity to speak today, and I also respect this body's opportunity to allow me to speak. Mr. Carroll referenced an attorney who testified and referred to some jargon that you're not familiar with. Let me offer this. The attorney should know that the Office of Disciplinary Counsel does not issue formal opinions no longer. They only do so on issues of general legal necessity. He can certainly address his concerns to the Office of Disciplinary Counsel directly. Let me read for you Rule 3.6 on the Rules of Professional Responsibility before I move forward. And these are rules that I'm governed by. Subsection A, a lawyer who is participating or who has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing the adjudicative proceeding in that matter. In English, I, as the attorney of record in both litigated matters, the GMO litigation and the injection well litigation, am prohibited by rules of professional responsibility from making extrajudicial comments. That means a comment outside of court that may impact adversely, one way or the other, the litigation pending before the courts. Both matters are currently pending before the courts. I can give you the procedural history of those matters. I can give you what's currently filed in those matters and how those documents were filed. As it relates to the matters itself and the strategy, you all know that we discussed those issues in executive session previously with the Policy and Intergovernmental Affairs Committee and currently with the Committee of the Whole. That information is protected by executive privilege, and I will not reveal that information. However, subsection C says, notwithstanding, paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect the client from the substantial, undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. That means I can, as much as possible, respond to some of the allegations that are clearly, in my view, inaccurate and a misstatement of fact and a misstatement of law. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. With that said, I will start with, as you heard, the recurring theme that the County of Maui is responsible for a $100 million price tag and a penalty. False. The court has not issued a penalty. The penalty phase is in the future. It has not yet occurred. I would offer that all the testimony today is, to me, prejudicial to the interests of the county because it does not accurately reflect what has actually happened in the courts. There is a risk that there's a penalty that may be implemented. That penalty, at whatever number, has not yet been issued. Everyone assigns a value to me. If it's true, I accept it, but it is not. If there's any, to me, discussion about that litigation and the prospects of a penalty associated therewith, that discussion should be made with this body in executive session. Those issues are for future risk and exposure. As it relates to the injection wells and its operations, as I've said before, the Department of Environmental Management has been compliant with the underground injection control permit, which is currently being considered by the Department of Health and the Department of Environmental Protection Agency. We applied for, as I stated before, the NPDES permit in November of 2012. That's of record. There's nothing that I can do to get the Department of Health to issue that permit. We can stay here all day and get into the nuances of the litigation. That matter has been fully addressed in the previous committees. Unfortunately, a lot of the discussion has occurred in executive session. The information that is out there that these people, 50+ people that testified to today, in my view, characterized as misinformation. I believe that majority of the people are passionate about the topics, and that's fine. But please present accurate information that's truly reflected in the positions taken. Apparently, I'm also, based on some testimony today, the author of the initiative itself incorrect. I did not author that. Apparently, I'm also the author of the language as written on the ballot. So too incorrect. I'm not certain how that misinformation is developed, but it is misinformation at its core. I think that if you look at how we've handled litigated matters, I think we've been focusing primarily on who is our client, and unless an individual is identified in the pleading, our client is, by charter, as you know, and we spoke about in the committee, the County of Maui. If you read our charter, the County of Maui is that body politic. It is not an individual. My obligation rests with the charter provisions and its mandate that I protect the interests, and I'm the legal representative of the county, the council, the mayor, the deputies, the department heads, the employees, and the various committees. I don't read the charter to say all constituents that may have a disagreement with the positions taken in a litigated matter. I don't read the charter to say that every constituent that presents testimony here today is my client. My client is the body politic. If this body wants to expand that authority to include the general constituency, then I would suggest a charter amendment be made to allow the Department of Corporation Counsel to represent individual constituents before any other matter. Until that occurs, my read of the charter is that my role and responsibility is to represent and provide advice to the County of Maui, the council, the mayor, and all the remaining clients that I have. I do not believe that any of the positions that I've taken in any litigated matter is contrary to the interests of my client, the County of Maui. I also stand by every position taken in every litigated matter as it represents the true interests of the county as a whole, as opposed to any select group or 50+ testifiers that are or may believe that my interests or my representation is adverse to their particular interests. I do not take any negative ill will from their testimony. I do not want to take this time to disparage any testifier in particular. I want to offer to you generally that my obligation under the charter and under the ethical boundaries that I operate by is to serve the County of Maui in the interests that best serves the county. I apologize if that interest and my representation may be contrary to some of the special interests that may exist. I assure you that at no time that any of the large corporations that were alluded to today had any influence on any of the decisions that we've made in defending the county and its interests. Quite frankly, I think that some of the procedural steps taken in the GMO litigation, without getting into the details, has provided the movement the opportunity to intervene, which we did not object to. You can look at the documents that say that. Apparently, they've hired their own counsel, which is great. I'm curious to see how their counsel is able to dispatch their positioning. I don't agree that the positioning of the movement is entirely consistent with the positioning of the county. And I think that without getting into and violating my own rules of professional responsibility, if there's any questions at this moment, I'm welcome. I will welcome any questions from this body as I report to this body. I don't think that anything that I've done has been inconsistent with the interests of the County of Maui. Thank you.
Thank you, Mr. Wong. Mr. Carroll.
Thank you, Chair. We had a testifier come before us and say, what doing right is not always popular, and what's always popular is not doing right. In this council, every decision we make falls in one of those categories. To the community and my fellow members, I hate executive sessions. I don't like executive sessions. We are forced to go to executive sessions because of the way our legal structure is in the courts and other places that literally force us into that situation. And when we come out of there and we have to make decisions, the public is telling, gee, what did they do? How come they're saying yes? How come they're saying no? How come they did this and that? And we cannot say we are bound by these executive sessions. There's so much information that I wish that I could tell the public right now, and I think every council member over here feels the same way. It's difficult. Pat Wong ended up being the focus of the concerns the public has. And those concerns are legitimate. They have strong, legitimate concerns. They're concerned about our community. They're concerned about injection wells. They're concerned why, when the referendum passed, why action hasn't been taken by this council. It's been explained why, but those explanations are not satisfactory to the general public. It is very, very difficult. It would be easy in this case just to go over there and say, I'm sorry, we're not going to approve Mr. Wong. That would be the popular issue. That would be the thing that everybody would look at us and say, oh, wow, they're listening to the general public. Unfortunately, our mandate to represent our people and represent these islands, the people in it, the sea around us, do not allow us to go over there and do the popular decision. We were elected, as was brought out by many testifiers, to represent our people and this land and the sea around us. And we need to make the decisions that will protect this. We need to make the decisions for our children, our grandchildren, our great-grandchildren. We talk about 7 generations before and 7 generations afterwards. I myself am working toward it. I have 10 great-grandchildren. It's something I don't take lightly. Every decision, I study it. I listen to everyone. I listen to every testifier seriously. And I weigh it against what we know from executive sessions and other places and what Mr. Wong has brought forward and what other people have brought forward. I wish the system was different. I wish that we didn't have executive sessions. I wish everything was more open, but it's not. And we, this council, do not have control over that. It's just the way it is. I would hope that bringing Mr. Wong down over here and his explanation and what the council members know from the executive sessions, which I choke that we cannot share this with the general public at this time. I don't know if certain time passed that people can find out really what happens and what goes on in there. I'm not sure if there's some avenue for that. I wish there was. But I thank the chair for allowing Mr. Wong to come down, and I thank the council members for their consideration. I seconded the motion. Before Mr. Wong spoke, I was waiting to see what he said. We know what happened, but I felt it was really important for him to clarify where we're at and what has transpired. What really bothers me is we're going to hear from people that don't like this decision, oh yeah, he was just blowing smoke. I'll tell the general public right now and anybody that knows me, I personally is saying he is not blowing smoke. He has done his duty, he has done his job. People are dissatisfied with the results. I'm not happy with the results, but it's something that we have to live with, and it's some things that we just do not have a complete control over. And we need to work harder and try to make it better. Mahalo.
Thank you, Mr. Carroll. And I'll just add to that I think all of us sometimes feel, for lack of a more artful term, muzzled by executive session. But it's that way because of our legal system and the challenges that brings to us. I would also like to point out that in our past meeting regarding the injection wells, in open session, Mr. Wong laid out all the parts of the case that have been before us in order to let the public know up to a certain point what our challenges are, what the case is, and so forth. So, and I believe Vice Chair Guzman and Mr. Wong agreed on that in order to try to counter some of the concerns that you've just expressed very well, because the public needs to know what our challenges are. We can't share every bit of it with them, and there's a point at which they have to trust our judgment. And with that, I'll open it up for other discussion. Members, Ms. Baisa?
Yes, thank you very much, Chair. And I would like to say that it was a very difficult morning, and I certainly feel very affected by all of the testimony that was made this morning. I feel very sad that we had to do that, because as has been stated by Mr. Wong, there is a lot of misunderstanding about exactly what's going on. And I heard repeatedly about us owing the $100 million and about him being the author of the language and all of that, knowing that that was not true. But it isn't our place when we're accepting testimony to argue with the testifiers, but to receive the testimony. And so we have to sit here and patiently try to listen to everybody's opinion, and it's very difficult, particularly when you'd like to say, no, let me explain, but a lot of times we can't, and a lot of it we can't.
Rated M for mature.
My name is Max Caulfield. I'm 18 years old. After 5 years, I'm back in my hometown. Then something changed my life forever. Where am I? What's happening? I discovered I could reverse time. Get in, Max! Then life started getting strange.
Successfully, very creatively, and it's been my opinion that he has prevented the county from having to spend millions and millions of dollars because he has great skills So I would ask people to be balanced and to look at everything fairly and not to judge him solely on something that I don't think is well understood. And it's nobody's fault, it's just the process. So I will be keeping my support for Mr. Wong. Thank you.
Thank you, Ms. Baisa. Ms. Cochran?
Thank you, Chair. And yeah, it was quite a exciting morning. And, you know, for me, the number of testifiers represents a whole lot more bigger voice that actually could make it to this room today on a mid-morning, midday Friday. And, you know, and I agree to a certain extent with Ms. Baisa in regards to the couple huge issues that were brought up over and over today. But what I see from the testifying also, and yes, there's some misnomers in regards to what you explained, Mr. Wong, and thank you for that, is that I felt, and I know I've said it before, that we should have never gone there in litigations. But here we are. And I think the feeling and the thought is because we are here, now there is risk of multi-million dollars of taxpayer dollars, possibly, it's all possible, to be forked out for litigation, for fines, penalties, and what have you. So that's yet to be seen. So, you know, and just the point of the whole initiative and voters, first-time voters, I think Ms. Rego brought it up. She said we got the lowest voter turnout in the state, but actually it's in the nation. And my district, West Maui, unfortunately, is the lowest of all. And there were many first-time voters that spoke out, and that is why they came out. And I hear their voices, and I hear their pleas, and I never want to let them down, to let them feel like, well, yeah, in the end, it didn't matter anyways. You know, the idea, the example of Humboldt's mayor and their attorneys, corporation counsel, working through whatever initiative went there to try and figure out the parts that could work and the parts that didn't work. They were going to set it aside. So to me, there are always ways and solutions and different efforts and more creativity that could have been put in to helping urge this forward. And personally, I don't think enough was done. So I kind of look at things a lot differently. You know, and there's no secret that pretty much the people that are here were people that I stood up and said, I'm your voice, you're my voice, I'm going to represent you. And you know what? I will till today. I'm not going to let anybody down. And when and I want to know Mr. Wong's quote, that statement he said is his position is the county's position. Well, I am the county. The 51 testifiers and the people they represent in this county are the county also. So there's a conflict there in regards to, is it county administration's voice or is it county? I mean, we have to debate this all the time. I understand. That is the hardship and the tough things we got to make the calls on as being in this seat. So it's never easy. No, it's not popular. Right and popular don't go hand in hand all the time. And, you know, I'm always never afraid to be not so popular. But I'm always, for me, deep in my heart is about right. It is about what I believe in. And so, Chair, those are just my comments here today. And I just want to thank this community for stepping up and speaking out. And the whole reason for this whole democratic process. And when I heard those words over and over today, that they feel like the democratic process is failing them, that scares me. It saddens me, but I'm glad I'm here to be part of the process. Thank you, Chair.
Thank you, Ms. Cochran. Mr. Couch?
Thank you, Mr. Chair. You know, several members already said a lot of what I was going to say. What's popular is not always right, and what's right is not always popular. That was said. One of the things that we have to remember is we're in a republic. We 9 are chosen to represent the people, not only the majority, but also the minority. We're supposed to, as part of a republic, is to protect the minority as well. You know, we had 54 people who came out because they were all ginned up on Facebook and got here last minute. Could have happened the other side if the other side wanted to come out too. in response to this, could have had just as many, if not more. So I'm not saying that these folks are representative of the whole county. They're representative of their side of the issue. And then also, we all know that the charter prohibits change. We're talking about the moratorium. The charter prohibits change, for us to change it for a year. So there is no opportunity to tweak this and tweak that. We were told yes or no, and that was it. And then we can't do anything for a year anyway. So there were, talking about the Humboldt mayor and whatnot, maybe their charter or whatever they did for their initiative, they could change it. We can't. We have, our hands are tied in this matter. So I think Mr. Wong has, and as we discussed in committee with the 9-0 vote, Mr. Wong has done an exemplary job at protecting this county, and I see no reason to change my vote. Thank you.
Ms. Crivello.
Thank you, Chair. I too can appreciate the process. I think we had there was a good orchestration of turnout this morning to try and dispose of Mr. Wong because of their support and belief with the initiative, as well as their concerns with the testifiers in regards to the injection well. So as I was listening, I was trying to go back to when it all first came before us. Came through to us because the charter allows it. And the initiative came before us and before our policy and intergovernmental committee. And it was, gosh, we had discovery after discovery and all kind of vetting to see how we were going to come out to have it. So the wording, if my understanding is correct, of the initiative was put together by the Shaka group. And then the process went through as to how we would get it on the ballot. And I understand that both sides, Shaka as well as the pro-GMO side, had opportunities to comment on the ballot language. And ultimately, the officials, the county clerk, corporation counsel, as well as the state election office had the final say. But I think both sides had concerns, and the matters were raised. And there was quite a bit of testimony in regards to the language of the ballot. And apparently it worked for the yes in support of the initiative. I also heard from testifiers that our corporation counsel failed to respond to upholding, if I heard correctly, the so-called law. My understanding at this point, it is currently not a law. It's in the legislation process with the initiative was allowed and it was voted upon, but I would think that we would have to, as the county legal people, should defend the enforcement and implementation of the law. And to me, that is their ultimate process with the initiative was allowed and it was voted upon. But I would think that we would have to, as the county legal people, should defend the enforcement and implementation of the law. And to me, that is their ultimate responsibility, but it's not a law yet. And for whatever reason, it's in the hands of the court. We can also go back to what's happening on Kauai as well as Hawaii Island, and you know, the kind of outcomes that have come out on the rulings. So for us to say that Mr. Wong did not make the right call, maybe in the opinion of the testifiers, perhaps. But I think we need to be mindful of the legal and fiduciary perspective that, what type of position was taken by not stepping in at this stage in defense of the county. And should it become law, as it may be ruled by the courts, then he certainly has a responsibility to uphold that law. But until then, I also wonder about the concerns that I believe every testifier had about the injection wells. And, the injection wells have been there a real long time, I understand. And we are still in litigation. So wherever they're coming out with the information, I don't know. It is what is happening correct, but the Corporation Counsel is in a position to litigate on our behalf. And that's the process that we are going through now. And I also like to make mention that, yes, democracy sometimes does not listen to the minority. Democracy will listen to the majority, which today, in regards to this initiative, is our Maui voters. But the minority, and if we were to say home rule, Molokai voted in a vast majority of no, but they ended up being the minority. I just want to make that, because we've heard democracy. I've heard whatever side one would take. I think it's sort of unfair for us to use this issue or initiative in a sense to make the determination on how we will choose or not to choose, reappoint Mr. Wong. I think we need to keep in mind that in reference to the many, many, many issues that we deal with, we look at the fiduciary perspective that how much our county comes out winning. And that was why my original vote was yes to get it to this agenda. And I believe at that time, all 9 of us voted yes. And I stand by that today. It may not be most popular to all those that testified and those who supported the initiative, but we have a big picture here to deal with and not just one issue. There's many, many issues that I've learned in my first term that we have to deal with and look at how the county survives or continues to provide all the type of services that is demanded from us. Thank you.
Thank you, Ms. Crivello. Mr. Hokama.
Thank you, Chairman. I listened, well, like the other members this morning, to those that testified. Let me just give my comments in this manner. I had to work very closely with Mr. Wong over the last 4 years as the former policy chair. And we worked on many, many litigation issues, claims, settlements, personnel issues, some were contractual issues. And I will be upfront, Mr. Wong and I did not agree on everything. But I will tell you that at no time did it ever come through a thought in my brain that Mr. Wong was not working in the interests of the county. Not once. It is not an easy task to be Corporation Counsel. We can go through all the councils since the 60s when we went from the Board of Supervisors to this chartered form of government. Some corporation councils took a lot longer to be confirmed, depending on which administration you want to look at. But I will speak from a more big picture standpoint. I think Mr. Wong has been consistent in representing the best interests of the county. And when he gave his definition of the county, that is my understanding as I read the charter also. You know, we're not sitting on an appeals court or anything, but regarding a proposed ordinance, you know, one of the issues that I look to the court for guidance is, can it contravene the existing charter? And there are provisions in the proposed ordinance that goes against the existing charter. The charter, as I understood, the pyramid of documents, and those brought up the state constitution also, which I was very fortunate to be one of 102 delegates that wrote this current version of the Constitution. So I understand the comments made regarding it. Is the same with the charter of this county. It was written by our people, and that is our basic founding and determining document that we base all our powers by, our responsibilities by, our duties by. It's specified in our charter. So for me, Chairman, unfortunately it is in court, but there's fundamental questions. Can an ordinance override the charter? Because that ordinance proposes to do such, override the charter. That disturbs me. And I know what will that do with every other decision made based on the charter being the founding document or the guiding document. I would say, in my experience in being around this building for close to 60 years, I think Mr. Wong is one of our better corporation counsels. And I say that with some humility, Chairman, knowing other corporation councils and knowing how other counties around the country operate. But I would say, working with him, seeing how we've and again, I agree with you members, it is hard because we cannot divulge what I consider very critical information regarding this consideration, but it is privileged information at this point in time, and we are not allowed to speak it or the details in this open session, Mr. Chairman. So I'm finding it difficult to fully express my sentiment at this point in time. But, you know, Lanai has trusted in me. I believe I have ended up on a lot of the short end of votes because of what I believe is right. But today I'm going to continue to follow how I've based all my decisions serving the people of this county, the people of my island, and I'm going to do what I believe is the best thing for the county of Maui. And so I'll vote accordingly, Chairman. Thank you.
Mr. Guzman.
Thank you, Chair. I think I would like to refer to what we discussed about during committee regarding Mr. Wong's appointment. And I know that several of us members, I believe Ellie Cochran, myself, you, Chair, and Mr. Hokama had stated on the record that we had concerns in regards to Mr. Wong and the position of Corporation Counsel as it being, in my words, inherently biased based off of the charter because of the fact that the mayor appoints, we confirm, but the mayor initiates any termination. So basically, I always had a problem with that in terms of where does Corporation Counsel's loyalties lie. And so that still bothers me in that sense. I did propose a charter amendment
although it died in committee, to allow the council to have the initiating power to terminate, so to have the corporation counsel position be more in line with balance. When this all started, let me refer to the position itself, corporation counsel. So in our charter, that position is the chief legal officer, the chief authority in terms of legal opinion for the county. And we have the executive branch, which is the mayor's administration, and we have the legislative branch, which is the county. And in parallel to that, we go to the federal government. We have the U.S. Attorney General, which would be comparable to our corporation counsel. We have the legislative branch, which is the Senate and the House, which is comparable to us on the council. And we have the executive branch, the president's administration, and our mayor's administration. So when it comes to who is the chief legal officer, who makes the decisions of filing a lawsuit or defending a lawsuit, according to our charter, is very vague. It doesn't specifically state that the corporation counsel has that authority, but in past practice, it's always been corporation counsel. And in other jurisdictions within the state, it's always been corporation counsel to make that determination whether to defend or to file a complaint. So that being said, there has been case law out there from our Supreme Court of Hawaii, case Harris versus DeSoto, 80 Hawaii 425, 1996, if the general public would like to look that up. And that case from the Supreme Court decision basically says that, and I might be putting this in layman's terms, saying that the council's authorization within a litigation or jurisdiction comes in when the stage is at settlement, when there's money to be appropriated. Then the council has authorization or the jurisdiction to come in to either settle the case or not settle the case. Before that stage of settlement, the council does not have what you'd say, the other stages of litigation, other matters. We don't have the power to dictate to the corporation counsel how to handle that case, whether to form an injunction, dismiss the case, so on and so forth. We only have the authorization and jurisdiction to come in when the case is at settlement, when monies and appropriations of the county is at stake. So until then, we haven't been able to even touch the GMO issue as an authoritative body. The chief legal officer during the litigation stage, that's his call. That's his job and duty. I'm not so familiar, I don't have the knowledge of what goes on in that stage in terms of the corporation counsel, but I can only assume, based on the cases that I've seen, that the executive branch, the mayor's office, and the corporation counsel may be communicating with each other during the litigation stage. But I don't know, because we haven't had that item before this body to ask that question. And until that happens, until the stage is where we, as the council, are required to make a decision, we are not going to be involved in it until that time and stage. And that might be something that we need to look at in the charter, whether we can amend our charter to allow us to have that authorization to direct the litigation. I think some jurisdictions tried. I think it failed in terms of, I think, the decisions, especially in this Supreme Court case, it failed. And right now that is the citing case that we follow. I think Mr. Wong has done his best duties as Corporation Counsel, aside from, like I said, the remarks that we had during the committee. I had my own concerns, and I have, I think that I've overcome those concerns. And I know that him knowing that we are concerned about him being more in balance with the council and the administration moving forward, he's going to make sure that that the balance is there more often, or is. So this one is tough because never is it easy to be the attorney for so many different parties, you know. And so at this point, I'll just reserve my comments until we are in further stages for the GMO issue. In terms of the injection wells, oh, let me make one more side comment with the GMOs issue. The county did not file the case. It would have gone to the normal process had it not been for the seed companies filing a lawsuit. And once that lawsuit was filed, it's in the hands of litigation, the Corporation Counsel. So we as this council had nothing to do with democracy of that being obstructed. It was a judiciary lawsuit that stopped the democratic process. Other than that, it would have gone through it in the normal course. And another issue that I would probably state is the initiative itself, the first of its kind in this county. So we weren't really sure whether all of the nuances could have been covered in our charter, because that was our founding fathers' drafting of the initiative process in our charter. So when it came to the council, when they had enough signatures at some stage, and it came to the council, the charter did not require us, or it prevented us to make an amendment to it. And so there's a defect in our own charter that, had it been foreseen or been able to give the ability for the council to make amendments to the initiative to basically correct some of the charter conflict, and then it being moved forward to the ballot, then we could have done it. But the charter didn't allow us to do it. So there again is not necessarily the county obstructing democracy. It was the charter itself, which was initiated by our founding fathers, that did not foresee this happening, because this was the first of its kind ever to come through. So now we know, we've learned our lesson, that we basically have to go back to the charter and amend it to have a second process, a second tier of review before it moves on. When it first came up when it came to the floor and we had public testimony, I had reviewed the language, and in my mind felt that it was flawed. It had flawed language. There was an executive session taken. I voted against going into executive session. I stayed out of executive session. But in my mind, I thought, why can't it be done in open session? Because if it was told to us or the public that certain provisions of the initiative was flawed, maybe the Shaka movement would have reconsidered or made some kind of changes themselves. I don't know. That's all hindsight. You know, we're in the stage that we are right now, and we only can move forward. And for me, I always...
Rated M for mature.
My name is Max Caulfield. I'm 18 years old. After 5 years, I'm back in my hometown. Then something changed my life forever. Where am I? What's happening? I discovered I could reverse time.
Get in, Max!
Then life started getting strange.
Los Crispy M&M's están de vuelta.
¿Qué estás haciendo?
Me pediste que le dijera a todo el mundo que los Crispy M&M's están de vuelta.
Te dije a todo el mundo.
Ah, los Crispy M&M's están de vuelta. Los Crispy M&M's están de vuelta.
As you all know, I've had my differences with Mr. Wong over certain issues, some of them similar to the concerns that have been expressed by Ms. Cochran and by Mr. Guzman. But again, it would be much more comfortable for us to explain our positions if we could divulge things that were discussed in executive sessions, but that's not an option. When I look at Mr. Wong's work, I believe that in the overall view of his caseload and the direction that he has provided us in executive session, the direction that he has provided for the administration and for this council, that overall his production, his focus has been on the right track. I don't think we'll ever agree on everything. I don't agree on everything with my own wife. But it's with the understanding that he's done a very solid, credible job in many, many, many cases that have been presented to us. And it is on that basis that I supported him in committee, and I will do so once again. I do want to say that I'm very thankful to hear from the people that came out today, because it's a reminder of the passion. It's a reminder of, in some cases, what I believe is some misinformation. I believe it's good for us to hear the concerns, and because it's an educational process. You know, working in this room is an ongoing educational process. I wish we were able to educate you on some of the issues that we deal with behind closed doors. But again, as I said, that's not quite possible. Mr. Wong, I'm willing to give you a brief statement in closing if you so choose. If not, I'll ask if there's any further discussion. Mr. Wong?
Thank you, Chair. I don't believe I have anything further.
Okay, thank you. Any further discussion, members? Ms. Cochran.
Oh, thank you, Chair. And I just wanted to highlight upon what Mr. Guzman had mentioned, because I think that was definitely a huge sticking point during our committee discussions in regards to the reappointment of Mr. Wong. And you know, it still doesn't sit 100% well with me, but Mr. Guzman mentioned just the way the charter has been set up. And he and I did try and push through that adjustment to the charter in regards to making this position of corporation counsel a lot more accountable to all, because I still really feel that the alliance more so, or allegiance, will be towards administration. Administration is the only body that can actually initiate the firing. We all take part in the hiring, but then appointment, then we reconfirm, but then we cannot initiate a dismissal. And for me, that in itself says why things go a certain way. And thank you, Mr. Guzman, for pointing out that we end up at the end of all the sort of the you know, litigation matters. The settlements come through, we have to figure out, is that worth the money? Do we want to spend it or not? But in the beginning, we're not the ones who pick and choose where anything's going to go, or if it goes. So, you know, and I still want to see a lot more risk management and preventative measures. We talk about all these other cases that come through us, and you know, I see things that or potential, again, a litigation coming to this body, and it's bothersome because, again, it's a settlement and it's a dollar amount and it's taxpayers' money. So, you know, again, I just wanted to chime in and expound upon Mr. Guzman's comments because I feel the same. Thank you.
Thank you, Ms. Cochran. Mr. Guzman, you had another comment?
Yeah, I know this is probably outside the matter, but once we have an opportunity to have the authority to chime in with the GMO case, I probably would be asking one of the questions that was the general theme of a lot of the testifiers, which was the position taken by Corporation Counsel to not defend the initiative. But that's something that we would have to discuss probably in executive session. But to let the public know, there is case law out there that allows the Attorney General of the states and even the Federal Attorney General to have an exception of the duty to defend and enforce acts of Congress and the Constitution. And there's case law out there, and I believe there's 3 prongs. And if the Attorney General can satisfy the prongs, then they would be exempt for having that duty to defend. I don't know whether those prongs have been met because we haven't had that opportunity to have that case item before us. But I'm fairly certain and hopeful that the analysis was completed by Corporation Counsel, and he was justified in his position not to defend the initiative. So I just make that statement. Thank you.
Thank you. And to Ms. Cochran's comment about the risk management, I think it's to Mr. Wong's credit that he's taken the risk management department into his office specifically for the reason you stated, or the concern that you stated, so that he can be aware of challenges long before they turn into claims. And I think you know, that's one of the areas in which I give him a lot of credit, because he's moved in a direction that is going to be very helpful to proactively keeping departments from doing things that are going to get them into hot water. So, that, Mr. Carroll?
Thank you, Chair. It's just that what Ms. Cochran brought up last year, I forwarded it to this council to go to committee of legislation addressing that the council could initiate the release or firing of Corporation Counsel. And that is in, I don't know if it's in committee yet, but I did forward it that to this council last year.
Okay, thank you. Any further discussion, members? Seeing none. All those in favor of the motion before us, please signify by saying aye.
Aye.
Those opposed say no.
No.
Read 7 ayes, 1 no, and 1 excused. Measure passes. Mr. Clerk?
For the record, resolution